Wills versus trusts in Georgia, what's the difference and which one do you need? If you're confused about the difference between a will and a trust, you're not alone. Whether you're trying to protect your family or avoid the probate process, these tools work in different ways. They both allow you to decide how your assets get distributed after you've passed away, but they function completely different. And in this video, you're going to learn how wills and trusts work in Georgia, the pros and cons of each one, how the Georgia probate laws affect your decision, and which option might be best for you and your family. A will or a last will and testament is a legal document that allows you to outline how you want your assets to be distributed, who should be the guardian of your minor child if you have one, and who should be in control of managing and distributing your assets after you pass away. Now, Georgia has its own rules on how a will should be set up. The first one is that it has to be in writing. A voicemail, a text message, or them just telling you what they want to do with their assets is not going to be a legally valid will. You have to specifically outline how you want your assets to be distributed, print that will off, and then sign it in front of a notary and 2 witnesses. Georgia allows self-proving wills, which will allow you to speed up the probate process if you have it notarized correctly. And if you pass away without a will, the courts will not have any instructions on how you want your assets to be distributed. So those assets will get distributed per the intestate laws of Georgia, which state that your assets will get split evenly between your kids and the surviving spouse, with your spouse getting a minimum of 1/3. And if you do not have a surviving spouse, it will get split evenly between the kids. So what are some of the pros of having a will? It's simpler and less expensive to set up. It lets you name a guardian for minor children, and it works well for small or less complex estates. Now, what are the cons of having a will? The first one is going to be it forces your assets to go through the probate process. With a will, your assets are still in your personal name, and any assets in your personal name will have to go through the probate process before they can be distributed out to your beneficiaries. When your executor files your will at the probate courts when you pass away, it becomes public information. Everyone can see your will, the assets you're passing them down, and who those assets are going to. The third one is going to be it does not account for incapacity planning. So if you become incapacitated for a car accident or a health emergency, it does not allow anyone to step in and start taking over the management of your assets. Let's talk about what is a trust in Georgia. A trust is a legal entity that allows you to put the assets inside of it so it can be managed and then distributed on behalf of your beneficiaries. With a revocable trust, you can be the trustee and have full control over the assets inside that trust. You will be able to change, amend, or cancel that revocable trust at any time. And then when you pass away, your backup trustee will step in your role as trustee and take over the management of those assets. Those assets will avoid the probate process completely. You can distribute them directly out to the beneficiaries per the instructions inside of that trust document. In Georgia, you can have either a revocable or an irrevocable trust. A revocable trust avoids probate. An irrevocable trust gives you asset protection and avoids probate. Any assets inside the trust will avoid the probate process when you pass away, and trusts are private. Unlike a will, the trust does not need to be filed with the courts when you pass away, so all the trust documents and the contents inside of it will remain private. Now, what are the pros of having a trust? The first one is going to be it avoids the probate process. It does not sound like a big deal, but if your assets have to go through the probate process, it can take 1 to 2 years for your family to take over the ownership of those assets from the point of you passing away. And if your family needs to hire a probate attorney to help them probate the estate, then that's going to cost them anywhere from $5,000 to $15,000. It keeps all of your affairs private because you do not have to file the trust document with the probate courts when you pass away. No one's going to be able to see that trust document, who you're passing those assets down to, or what assets your family has. It also allows you to do incapacity planning. So in the event that you become incapacitated and your assets are inside the revocable trust, your backup trustee will step in your role as trustee and take over the management of those assets seamlessly. And it also allows you to control the distribution of the assets inside that trust. Unlike a will, which is a lump sum distribution, the revocable trust will allow you to control that distribution. So you can do things like age-based distributions when they turn 20, 25, 30, or event-based distributions when they graduate college, get married, or buy their first home. Now, what are the cons of using a trust? The first one is going to be it's more expensive to set up. Trusts are going to cost anywhere from $3,000 to $5,000 for a revocable trust and $6,000 to $7,000 for an irrevocable trust. The second one is it has to be funded. If you do not put your assets inside of the trust, it is not funded, and those assets will not have asset protection, and they will not avoid the probate process when you pass away because those assets are still in your personal name. They're not inside of the trust. The last problem is that the trust does not appoint a guardian of any minor children. The will appoint the guardian, but the trust will allow you to control the distribution of those assets to be able to take care of your minor child. Because with a will, your money will go to your child, but your guardian will be in control of that money until your child turns 18 years old, so you have no control over how that money gets used or the distribution of that money. Now, you might be wondering, which one do you need, a will or a trust? But a lot of people will just get both of them in the same package. So the revocable trust will allow all the assets to avoid the probate process, and you can name the revocable trust as a designated beneficiary on all of your financial accounts so that money money dumped straight into the revocable trust, and then you're retitling property into that trust so the assets are actually inside of that trust. And then we also include a pour over will, which will capture all the assets that you forget to or you don't have time to put inside of that trust, take them through the probate process like they would go anyways because they're still in your personal name, but they will dump those assets into the revocable trust on the back end so those assets can be managed and then distributed per the instructions inside of that trust document. And then we have a will, which will appoint the guardian of any minor kids if you have any. That way you are in control of who's raising your kids, and the courts are not appointing someone to raise your kids that you do not agree with. And then we're going to have medical and financial power of attorneys that will allow people to make decisions on our behalf in the event that we become incapacitated, and will also allow that person to manage any assets inside of our name when we become incapacitated if we have forgotten to put them inside the revocable trust. And then we'll have a healthcare directive which will allow us to outline the medical preferences that we have when it comes to treatment. So we can do things like do not resuscitate orders, end of life care, feeding tubes, etc. That way we are in full control over what happens to us when we cannot make decisions at the end of our life. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to some of our team.